Hi, I'm Marlene Gabauer from the Geek and Review. I have Stephanie Wilkins from Legal Technology Hub here. Hi, Stephanie. How are you?
I'm good, Marlene. How you doing?
Good. And you're going to tell us about updating of Legal Technology Hub's premium content, right?
Yeah, definitely. We have all new and updated premium categories and content on the horizon. If you're not familiar with it, if you haven't played around on Legal Tech Hub that much, Legal Tech Hub directory breaks down the available solutions in the market with a deep taxonomy that I believe has about 140 different categories at the moment to try to help people figure out exactly which tools serve which purposes. Of those 140, we're gradually upgrading a lot of them to what we call premium, and we've been doing that over the years since we started. And that means we do extensive research into the nature of the tools in the category, what they're designed to do, and notably how AI has changed the landscape. So we've been pulling together a lot of comprehensive guides for every step of the procurement process. So for each premium category, we have a landscape overview, an evaluation framework, a business case, a pilot guide, and a requirements template, and then any other information we think that's important. But the reason we're highlighting the updating of this is that, as you can imagine, there's a lot of work that goes into preparing these documents. And at the same time, the legal tech industry is changing so fast, especially in the age of AI. So it's a significant effort to keep them updated. And so what we've done is we've focused on really taking all of the content and all the categories we've had in the past, bringing them up to date so everyone can see exactly how AI has or has not impacted the landscape, what is new in the area, how the players have changed. We've seen a lot of mergers and acquisitions. And so people should expect to see a lot of that in the coming weeks rolling out. And it's massive project is really paying off. I'm excited about what we're doing. So if you are an LTH subscriber, be on the lookout for that. And if you're not and you want to learn more about our premium categories and what subscribers get to see, you can visit us at legaltechnologyhub.com and check it out.
Yeah, well, I'm very excited to see it too. So thank you, Stephanie.
Yeah, thanks.
Welcome to the Geek and Review, the podcast focused on innovative and creative ideas in the legal industry. I'm Marlene Gabauer.
And I'm Greg Lambert. And Marlene, today's guest has one of my favorite titles in legal academia, and that is Associate Dean for Research and Intellectual Life, which
It's a
to
good
me
one.
sounds like someone got promoted to Chief Curator of Smart People Ideas.
And that's a great job to have. We are joined by Ray Brescia of Albany Law School. Ray is the Honorable Harold R. Tyler Chair in Law and Technology and the author of Law 3.0, A Guide to Next Wave Lawyering. This is a book about how the profession changes when technology shifts what legal work looks like. Perfect for our podcast. And it's also about how clients buy it and how law schools train people to deliver it. So, Ray, welcome to the Geek and Review.
Great. Thanks for having me. I really appreciate it.
Can't wait to talk about this.
Yeah, Ray, before we get into the book, which is, the primary reason you're here, I do have to talk about your title. And so when someone hears, Associate Dean for Research and Intellectual Life, what's your day-to-day look like in real terms? And, kind of what are you responsible for there at the school?
Sure. Thank you. That's a great question. And I ask myself that every day. But I'm the least dangerous dean. I have no power. I have no budget. I have, nothing I can, I can't strip anyone of their titles or anything like that. But no, I support the research and scholarship work of my colleagues, really more as a coach than anything else. And to try to encourage people to try to draw out their ideas. I don't need to give a lot of guidance to my colleagues because they're all pros, but sometimes a little nudge, a little idea, a little reframing of something if someone's is blocked, metaphorically, but then also if there are things that might be getting in the way of them doing their best work, try to block and tackle for them. But it's I really enjoy the work. I love all aspects of my job, but writing is probably my favorite. Although being in the classroom and mentoring students is just so I'm so fortunate to get that opportunity. So it's a blend of, like I said, coaching and blocking and tackling. So I'm in baseball. We used to have a the player coach, right?
Yeah.
The guy who's on the bench, but then went into third base every half inning. I'm kind of a player coach,
All
right?
right.
So
So you're the
supporting.
Pete Rose of
Yeah,
academia
yeah, I guess he was a
law
player
schools.
coach. Yeah, he was a player coach
He
towards the
was
end of
there
his career. That's
there at
right.
the end.
Yeah.
Well, Ray,
But
on
not the
that,
bad
just
stuff, all the good stuff,
all the
Just the
I
good
good
play
stuff.
stuff.
hard, I work hard,
Yeah.
but I don't gamble.
Yeah, don't gamble on the work of your peers there.
That's right.
You'll be okay. But I'm wondering on that, just thinking about it, because you are this player coach that's across the entire bench of the faculty there, do you find that having that kind of spectrum of talking to so many of the faculty, that there are things that one may be doing that relay to something else, or a win that somebody else gets that you can then apply to someone that is stuck? Are you
Where are
finding
the
that,
connections if you're
yeah, that
finding any?
connection?
Yeah, I think the best support for I think this applies pretty much anywhere in many contexts. Whether it's students, whether it's faculty, that peer-to-peer support. So being a peer myself, but then also if I know that, by trying to know what my colleagues are working on and where I can be supportive, or where another colleague could be supportive. If somebody's trying to figure out a particular issue, and I know that somebody else has written on that topic, I can connect folks that way. So having, trying to be open and transparent about what I'm doing, try to understand and support the work of my colleagues, helps to try to make those connections both within the law school and also outside of the institution, because Albany Law School, celebrating its 175th year. It's the longest running
Yay.
independent law school in the country. But we are independent. We don't have a university beside us supporting us, but I do a lot of work with the University at Albany, which is part of the SUNY system, and making those interdisciplinary connections, which we'll talk about, and I talk about for the profession. I think that particularly in the area of technology, but we also do work in climate change research, game design. We do a lot of different things where lawyers and legal scholars can benefit from and can provide insight to other scholars, other professionals, like computer engineers, like climate scientists, and like game design. So we have some fun, and I do think it's great to engage in that kind of collaboration, and it's something that I think the legal profession doesn't do enough of, and should do more of, and it's certainly one of the themes of the book.
Yeah, so I want to dig into your other job, which is author. And how do you feel like the concept of Lawyer 3.0? How does the focus on job of lawyer and how lawyers work rather than tools? Is there a mismatch between what their self-described value is, what the client experience is, and what the real value is? How do you tackle that?
So let's start with the frame of Lawyer 3.0. So the idea is that I believe that we are at a critical inflection point in the profession. The last main inflection point we had, which created Lawyer 2.0, was at the turn of the 19th to the 20th century. And if you think about the legal profession in the earlier in the 19th century, it was, as one legal historian described it, a large amorphous bar. And after the Jacksonian era, there were very few barriers to entry for lawyers if they were white and male. That was pretty much, were you a citizen? Did you have the right to vote? You pretty much could become a lawyer whether you apprenticed with another lawyer, whether you, as Abraham Lincoln did, read the law, took out a loan to get a law library, read read Blackstone and a few other books, and hung out a shingle and waited for people to walk in your office down Main Street in your town. So that's the ethos of Lawyer 1.0. And it really was, from colonial times up to the end of the 19th century, that's what the legal profession was, this large amorphous bar made up exclusively of white men. But so we have very few barriers to entry. Then we get to see, urbanization, immigration, mechanization, and we start to see the bar changing. And those, low barriers to entry mean that women start to join the bar, immigrants start to join the bar, African Americans start to join the bar, and elites in the bar start
How
saying,
dare
whoa,
they?
Whoa.
wait a minute, not so fast. And so, think of the things. If someone, you just walk down the street and ask somebody, when you think about the American legal profession today, what do you think of? What are some of the elements of the American legal profession? Well, law firms, law schools, bar exams, codes of ethics, these are all things that we created at the turn of the 19th to the 20th century, that very few of these items existed. There was, as you said before, at the top of the show, Albany Law School, but there were a smattering of law schools, law departments at different universities. But then we started to see law schools that gave people training to pass, sort of teaching to the test, minimal bar exam type barriers that people could take. And there were even many states had what was known as a diploma privilege. So if you had a law school in a state and you gave a diploma to somebody, they could enter the bar. And so you had law schools cropping up with correspondence. They're basically correspondence schools, and people could write in, send a check, and they'd get a diploma and they'd be a lawyer, right? And so that's, that's not a great system either, but that gave elites of the bar great pause. So they started to create, as I said, the institutions that we think of as the legal profession today, and that's Lawyer 2.0. And technology was absolutely a part of that. Technology, just like today, we'll get to today, Lawyer 3.0, but Lawyer 2.0, technology drove the practice of law in a lot of different ways. It changed what lawyers did, right? Because of the trusts and railroads and oil, and manufacturing, that lawyers had to ramp up the efficiency of their practice. They formed into law firms at this time to provide services to their corporate clients. They started to incorporate the telephone and the telegraph and even the typewriter. The rapid reproduction of judicial decisions changed how lawyers practice. So you couldn't just, walk into the court and sort of make noises about general principles, Your Honor, and your adversary would be actually citing cases, right? Which was just a change for a lot of lawyers. So we made it harder to become a lawyer. We made it more expensive to become a lawyer. So the ABA, together with the American Association of Law Schools. So the ABA gets started in 1878 in Saratoga Springs in upstate New York by elites in the bar, who summered in Saratoga, right? Literally, that's who it was who created the ABA. The American Association of Law Schools gets created in 1900 of the more established law schools, and they combine forces to make law school, number one, a requirement for bar admission. Number two, more expensive to attend. It's more years instead of, you can't, no more correspondence courses. You have to have full-time faculty, you have to have libraries. So we made it more expensive to attend. We created, more difficult bar exams. So we transformed the practice of law. again, partly because of the changes in technology, but immigration and urbanization. Fast forward to today, right? Technology is absolutely transforming the practice of law in a significant way. We've had technology creeping into the practice of law, whether it's email and scheduling and obviously legal research. And, about 20 years ago, we started using technology to scan massive OCR technology in discovery. But now I think generative AI and, predictive analytics is really going to make a significant change to the practice of law. And I'll stop there because that was a bit of a long-winded answer, but you asked a 5-part question.
Yeah. Yeah.
No,
No, we
this
brought
is
that on ourselves.
That's true. And I mean, I just want to say thank you for sort of setting that stage because honestly, I don't know if all of our listeners kind of know the history of it. And I think that helps sort of shape your thoughts about sort of where we're going.
Ray, one of the things you talk about in the book is that, there's this focus on there's a client's job that needs to be done. Talk to us a little bit about the concept of this job to be done and how it's fundamentally changed how a practicing lawyer determines what legal services to offer them now and how to scope that.
Sure. And so it comes from the late Harvard Business School professor Clayton Christensen, and he's famous for coining the phrase, disruptive innovation. But the job to be done framework is actually, I love this story. It actually was sort of emerged from a milkshake study, the famous milkshake study that he did where a fast food restaurant wanted to know why people were buying milkshakes, particularly, at a couple of times during the day, the morning, mid-afternoon, and at the end of the day. And so the interviewed the customers and sort of find out why they were buying a milkshake, particularly in the morning. Like I like a good milkshake, but like first thing in the morning, it's kind of weird, a little too sweet, right?
Pour it on your cereal.
Exactly. What's Elf say? The 5 food groups are, candy cane, candy corn,
sugar.
So it's for people. So the morning shift in particular was for people in their morning commute. They wanted to pick up something quick, something that would keep them engaged. It took a long time to drink it. You could drink it with, through a straw with one, holding in one hand. Other things like a muffin, you get crumbs all over you, a banana, like, oh, who's going to eat the banana in the car? So there's like, what, like they weren't necessarily, the customers were, and the afternoon, the evening drive, same thing. The afternoon was parents picking up their kids, wanting to give their kids something to do. The parents give a little bit of, a little bit of break so they could, make that transition from, their whatever they're doing during the day to, now they've got their kids. But so the idea is like, what were the customers hiring a milkshake to do, right? Problem were they trying to solve? And that's the job to be done framework. So when somebody purchases a good or a service, what job are they trying to satisfy? What job are they trying to get done? And if you apply that to the legal context, customers/clients of lawyers are hiring a lawyer to do is to solve their legal problem. It's not necessarily to have a lawyer for the sake of having a lawyer. It's to have a lawyer to solve their legal problem, whatever that problem may be. Another sort of famous, business school story is of someone who a CEO of a tool manufacturing company, and say, why do people buy a 1/4-inch drill? Because they want a 1/4-inch drill, or because they want a 1/4-inch hole, right? And so what is the job that people are hiring lawyers to do? They're not hiring lawyers for the sake of hiring lawyers. They're hiring lawyers to solve their legal problems, to address
and
their
I've,
legal
I've
problems.
actually heard it that they're not actually looking at it at legal problems, but more as it's business problems,
problems.
or it's personal problem, family problem, personal
Sure.
problem. So they don't see it in the legal lens. So I'm hoping you can give us an example. So let's say that I'm in charge of the intake process at my firm, and I want to just wipe it out and start all over again. How would you suggest that we look at it on this job to be done, cycle framework to recreate, say, an intake cycle?
Well, so a couple of things. I think you said something important there earlier, which was, they want, a customer slash client wants their business problem solved, or their border dispute with their neighbor solved, something like that. Yeah, the property line dispute. But one of the problems, and this is, I think this is endemic in American culture. Well, there's two sort of conflicting problems, right? A lot of issues are legal. A lot of tensions in our culture, in our lives, are legal in nature, that there's a legal issue that could solve a problem. And maybe there's too much law. And there certainly are scholars who write about that we are sort of
Too
shrouded
litigious.
in law. The law is all around, as one famous scholar quoted a low-income person saying. So there's a lot of legal stuff out there, right? One of the issues that accompanies that is that lay people don't always realize that they have a legal problem, or they have a problem that a lawyer can solve. So there's a marketing issue, in the sense, and I don't mean to diminish in that way, but helping people to understand that they have a legal problem in the first place is an important first step, right? And it may not be great to explain to somebody that they have a legal problem if they can't afford a lawyer, they don't know how to access a lawyer, they know some friend of a friend who knows a lawyer who once helped them with something once, So we have a job to do for lawyers, is to help people understand that they have a problem that could be addressed, that might be legal in nature. And there's a great legal scholar, Becky Sandifer, and she's done research in this area that a lot of people, either don't know they have a legal problem to begin with, think, they may think they have a problem, but it's God's will. They think they have a problem. They'll go to a neighbor, a friend, to help them solve it or to help them address it. So getting people to understand they have a legal problem in the first place is a task of Lawyer 3.0. So that's number one. Now, to get more specifically, so let's assume we've got a customer who may understand they have a legal problem, may understand they should go to a lawyer's office to try to address it. They may understand that, they have the means to do so. How would you approach that client? Well, the way we've approached clients for a century at least is the client walks in the door and we assess their legal needs, and we create what we might consider to be what Richard Susskind calls a bespoke suite of services, right? Like it's custom made for each client. In reality, lawyers really don't do that, right? It's if you're depending on your area of practice, someone walks in the door and you assess their case, they walk out the door, you think to yourself, well, now I'm going to develop a bespoke approach to their services. Really, what lawyers do is they say, well, Mary just walked in the door. Mary's case is a lot like Maureen's case that I handled 3 weeks ago. Let me start with what I did for Maureen and start changing the names and start working in that direction. But at the same time, we do tailor the response to client needs. And I think that one way to reframe how lawyers operate is, instead of triaging, the clients and saying, okay, what is the suite of services? I think that we can have a different approach to make the practice more efficient, more effective, is to have products and then triage the clients to meet the products that we have. So to develop sort of Model T approach to some legal problems that you can present to the client and say, this is a product that we have that will be much less expensive than the one with all the bells and whistles. And it should, satisfy most of your needs adequately. Here are the risks to using this product, and we can develop a bespoke product for you, but this is what it's going to cost. So putting those options before the client is a simple way to think about reframing what we do. And we can talk about some of the examples of organizations that are doing this, that do this already.
What's one that you think is pretty
A good
exemplary?
example.
So there's a great program called Citizenship Works, which I highlight in the book. And it's a program developed by an organization, Pro Bono Net. Citizenship Works walks people through the process of applying for citizenship, and goes through all the steps along the way, assessing whether somebody is eligible to apply for citizenship. They have no barriers to it, and walks them through the process and generates the application if there are no red flags, right? So that there will be a percentage of people who would go into the law office of immigration lawyer who would present a relatively straightforward case. Those people can go through the Citizenship Works process, and if no red flags are raised along the way, they will get their completed forms. And think of it as TurboTax, right? Lawyers long ago ceded simple tax preparation to things like A, to tax preparers, B, to online tools like TurboTax. And I could see the sort of turbo-taxification of different areas of law that would be a lot less expensive. Now, building those expert systems are expensive with the startup, but they have a long tail, and you can make up over time with volume. Now, something like Citizenship Works, then a user raises red flags in their application, the system sees that and said, as long as the person is answering accurately and honestly, it will identify the red flags and say, hey, you need to talk to an immigration lawyer, right? This is something that there's an issue here that you need more expertise than this system can provide. So that's one example of that kind of expert system that is available, and I think that lawyers can build more of those.
So I want to dive into this concept of limited scope services and tell us sort of what that means. I mean, is that sort of the productization we've been talking about, or is that something different?
So limited scope representation is something that's been around since lawyers started opening their mouths, right? Where you give whether it was at a cocktail party or at your office on Main Street, just giving some basic guidance to somebody who didn't want full representation. Just wanted some simple guidance. And sometimes the lawyer, who had, a relationship with somebody would say like, oh, this isn't a big deal. You could do this, you could do that, and, come back if there's a problem. We've codified that now in the rules to formally allow limited scope representation, which again is something lawyers have done since, again, they started opening their mouths, if the limited scope is reasonable, it's it's explained to the client. So a paradigmatic example of something like this is something like lawyer for the day programs. So in some housing courts, which are very high volume areas, very low representation rate particularly for low income tenants, but a lawyer for the day will be in housing court, and the client has the lawyer for the day.
Mhm.
And, if usually the lawyer won't go to trial for the tenant, but very few landlord-tenant cases do go to trial. They're often settled. And the lawyer can help navigate that settlement process for the client and try to make sure that their rights are protected. But that's it. It's at the end of the day, literally at the end of the day, we use that term metaphorically, but at the end of the day, the end of the lawyer for the day, they turn back into a fully operational and expensive lawyer. If they can't resolve the case for that tenant, then the tenant goes on, the case is probably adjourned, and then the tenant will not have representation on the return date of that case. But in a lot of situations, the lawyer can resolve the case, and get the tenant and the landlord to a mutually agreed upon settlement where the tenant's rights are protected, and the lawyer's interests are advanced, and that's a very constructive, common situation.
So that's a great example. So, okay, you have the lawyer for the day. Say they don't resolve it.
Mm-hmm.
And then that person is kind of cut loose. And, how does the lawyer kind of best explain that? Because, I'm thinking, okay, this is a person who would maybe normally be pro se, and like they get this help and then they're in the midst of it, and then they're kind of in the middle of it on their own. And so how does the lawyer explain that to their client without their client feeling like they've been abandoned?
Well, the rules require that if you're going to enter into this type of limited scope arrangement, the rules require that the lawyer, not only that the scope is reasonable, but that the client understands and gives informed consent to the arrangement, right? And so let's talk about that first piece of it, the reasonable in scope, right? You could say, look, I'm a criminal defense lawyer, and my specialty is entering into plea bargains for my clients. But I'm at, sort of at the tail end of my career. I've accomplished everything I want to accomplish. If you want to pay my fee, all I do is plea bargains, and the best plea bargains are those that are settled, on the eve of trial. My limited scope is I will only represent you in this very high stakes criminal matter, where you could go to jail for 20 years if you're found guilty. But if we can't enter into a plea agreement, then I will, as you say, Marlene, abandon you. But, that's the scope of that's my deal. Take it or leave it. And like I said, the best deals are struck on the eve of trial. So if on the eve of trial, I can't cut a deal for you, you're on your own, right? That's an unreasonable scope. Why? Because the client's going to be left in the lurch, the night before trial, and the lawyer throws up their hands and says, well, I did my best. I tried. Good luck, right? If you get work,
See you in 20 years.
Right. So that would be an unreasonable scope. So it's got to be a reasonable scope, but it's also got to be explained to the client. And so I talk about in the book, first, do no harm, right? The limited scope can't leave the client in a worse situation than they were if they didn't have any assistance. Right. So let's use that landlord tenant example again, but you can think of other high volume cases, consumer debt cases, bankruptcy cases, limited guidance that gives people a playbook, a framework for assistance beyond the assistance that the lawyer can give in the moment, right? Whether it's trying to settle the case, trying to, file the bankruptcy petition. Now, you have to also, the judge generally has to be made aware of the limited scope arrangement. So if you're in a situation where, like a bankruptcy case where you have to appear, you'd have to make it clear that you're only appearing for the purposes of filing a petition, or in landlord tenant, Your Honor, we're here to try to settle this case, but if the case doesn't settle, the scope of my representation is only to try to settle the case. So, just so everyone is aware of the situation. So again, client has to understand, has to give informed consent. And I think as a principle, you shouldn't leave the client worse off than if you didn't provide them any assistance.
So we've talked a lot about, and I think a lot of the individual lawyers, a lot of the folks that have hung their shingle and are going out and doing a lot of the grunt legal work. I want to know, how do you apply the Lawyers 3.0 way to more of a full service firm like Marlene and I work in? How do you see that working in a larger law firm?
So I think that, I got a chapter on full service 3.0 lawyering. I think we're already seeing some of it, certainly, as I said before, on making discovery more efficient. I think that folks are using generative AI to produce first drafts of documents. I think that's all it's good for now, not last draft of documents. Every day we're hearing about AI hallucinations working their way into the legal bloodstream, which I just don't understand how that it can, it literally is happening every day. So you have to be
It's
careful.
called laziness.
It's called laziness,
It's called
and
not checking
so
your citations.
not checking your citations. And I do think that there's going to be pressure on large law firms to adopt some of these tools to make their work more efficient and effective. In-house offices are bringing more work in-house using generative AI and other AI tools. Some of the large AI companies are marketing directly to in-house counsel departments to say, look, we can help you bring this more stuff in-house. So there's a real threat out there.
Yeah.
So
There's also hallucinations in those that come to us as
100%.
well.
Oh, absolutely. No. It's very risky. It's very risky at this point, right? I do think that we can look for efficiencies. We can look for ways to make the work go faster, be less costly to clients. I think, Marlene, you talked about the billable hour. We've been promised for years that we're going to go back to, or we're going to go to, whatever it is, flat fee or project-based pricing. So I think there's going to be pressure from clients who, it's almost like the equivalent of the most feared phrase that every doctor faces is, well, doc, I was on WebMD last night, right? And I'm certain I've got Legionnaire's
It's totally
disease,
me.
right?
Yeah.
And I think that we're going to see that, and we're already seeing it now. Former Trump lawyer Michael Cohen got in trouble a while ago. He forwarded some research that he did. I think it was on ChatGPT, forwarded it to his lawyers. Hey, here's some cases that I got that could support, my position. And they just dumped it into the brief, and they were fake. And that's like, I don't mean to criticize him, but it literally is happening every day, and I don't understand that. As you said, laziness, but we should know by now that this stuff is very risky. But we're going to see clients, and we're already seeing it, coming to their lawyers saying, hey, I did some research last night on, ChatGPT, and I think I can win. Here are the cases. And the lawyer's like, oh, well, no, let me see. And then
here's the first draft of the document.
Yeah, and
take it from here,
so,
check and make sure it's good.
Check and make sure it's good. But we're certainly seeing people using ChatGPT, it's almost like, my grandmother called the refrigerator Frigidaire, right? We talk about Gen AI as ChatGPT, but just Gen AI more generally. Even, research shows that even the databases maintained by the commercial legal research companies that use AI, research shows that they're also hallucinating, right? So these models are sort of described as, the most sycophantic intern you've ever had, who just wants an answer for you because they want to please you, regardless of whether the answer is correct. And I think that some of them, I use these tools every day, and usually at best as a, as an outline or as a, just to answer a quick question. But I always double check the work, because it's often, like a tick or two off, right? I remember, recently, doing something, I was asked to do a presentation on a paper I had prepared. Said, okay, I won't say the company that I use, give me a summary of this paper that I wrote, right? And it's like, that's not right, and I wouldn't have known that had I not known that it was wrong because I had written the underlying, document, right?
That's why I always tell attorneys to, when they're first using the generative AI, use it on something that you know backwards and forwards, because
Absolutely.
you'll
Yeah,
be
just so
able to
you
spot
can
what
check
it's
it.
good at and what it's not good at.
Yeah.
Yeah, I
And
mean,
and some things it's great for. I was working with a couple of other law schools, and we're trying to develop a course that we might do across a couple of different law schools for the types of issues that lawyers in a rural law practice in upstate New York face, right? So that's, very idiosyncratic, right? Farmers deal with or renewable energy contracts. You could think of lots of different things that creating a farm store, creating a brewery, all this stuff. And I just put in, it's like, let's see what it comes up with. Come up with a 14-week syllabus, a course that would be a survey course for rural law practitioners in upstate New York. And, in a matter of minutes, it came up with something, 14 weeks, subject matter. It was amazing, right? Would I take that and say, okay, here's students, here's the course? But it certainly was a head start. It was a great head start.
So I want to jump in on that. So what are the critical steps that are often overlooked, both, by lawyers and also by their firms when they find initial AI, messy? I mean, what type of guardrails should they have in place? What type of process should they have in place, to check hallucinations? What are the steps that you think law firms should or attorneys should be doing, but maybe aren't doing?
Well, I don't know what they're not doing, but it surprises me that we do see these problems basically every day, and that some practitioners are not checking the work, and it's minimum competence, right? Minimal competence is required to check the work to make sure that the laws you're citing exist, that the cases you're referring to are real and say what they say, right? So when I started practice as a legal aid lawyer, we had handed down, the briefs on XYZ issue. And I was taught in law school, you have to have read every case you cite in every brief. And so I went to read the original sources that were in this brief, these briefs that we would have on different topics. And I'd say wow, this really doesn't say what the brief says it says, so and that was, sort of the shelf life of this decision, of these decisions, of these briefs had not, sustained itself, definitely past their sell by date. And so but that's, basic competence, right? So you can use these tools. You have to understand their value, that they might give you a head start. They might provide an outline and some arguments, and they might even turn up some cases that you may not have found otherwise, but you have to do the background research and make sure that they're accurate. I practice in courts where, when I was in practice day in, day out before joining the academy, where it was not uncommon that you would have an opinion that was not otherwise reported, right? NOR, not otherwise reported. And you would, maybe your law office had secured the decision, so you were aware of the decision, and you would append a copy of that NOR decision to your brief. Everyone, if you think that this is, that how could you miss something like this? Look at the opinion, Mata v. Avianca, which was the big case, the big first case out of the Southern District on AI hallucinations. The judge adds an appendix to the opinion with the cases as presented by the lawyers, because the lawyers submitted not just citations, but the opinions right, were appended to the lawyer's briefs. The judge appended them to his opinion. And if you were in an area of practice where it was common to have opinions like that were NOR, you would say, oh, this looks legit, 100%, right? And I've talked to practitioners and judges about this issue for years since, it started emerging. And I said to people, we are not that far away from situations where judges cite hallucinated cases because they're in the briefs, they're in the minute orders, they're in the draft orders that have been submitted to them, they're in the proposed findings of fact and conclusions of law, and judges said, oh, no, that will never happen. And of course it's happened, right? So that's so there's a lot of risk of, spending judicial resources, spending litigant resources in tracking down these cases. But the real risk is that they get sort of transmogrified by some judge citing them, right? Then it becomes, part of the the body of legitimate law, So you have to do the homework. That's a long way of saying you have to do the homework.
Good. Well, you teed me up perfectly for our crystal ball question. Looking in 3 to 5 years, what do you think is going to be, the one biggest structural shift that you expect in how legal services are delivered?
So Bill Gates, is fond of saying that, we overestimate the changes that happen in 2 years and underestimate those that are going to happen over 10. And we are now, I think we're at the 3-year mark on the introduction of Gen AI, when, I remember people saying it was the end of the legal profession, right? And well, as Mark Twain said, the news of my death is greatly exaggerated. I don't think the legal profession is dead or dying, but I do think it's changing. And I think it's going to change. I do think that we're going to see more, of this turbo taxification, if you would, of creating more commoditized legal services that will be less expensive, that will be easier to deliver, and that will satisfy clients' jobs to be done. And the firms, the organizations that do that get out in front of that curve are going to be very successful. Now, I mentioned Clayton Christensen with the job to be done framework. His disruptive innovation idea is sort of also instructive in that the idea that when new technologies come online, the incumbent firms sort of tend to cede the lower end of a particular market, and that lower end of the market, the new technologies with fewer bells and whistles tend to satisfy the needs of the lower end of the market, but then they slowly start grabbing larger and larger market share as the technology improves, as people learn how to deliver services to a greater share of the market. So the individuals, entities, firms, companies, nonprofits that figure out how to use the tools available to bring more legal service to people at scale, I think are going to really change the way legal services is delivered for many people. To turn to Richard Susskind again, he says that there is a latent legal market. And I think that's accurate. 93% of low-income people and roughly 50% of middle-income people in America face their legal problems without a lawyer. And one of the main reasons is that they can't afford one. And, the person, the entity that can figure out how to deliver legal services, meaningful, effective legal services at scale will have the ability to really tap, what's that, a blue ocean strategy, right? Where there aren't legal services providers now. So that's number one. So that's part one of my answer. Part two is what what law schools can do is to help people understand the technology, understand the risks and benefits, but also on the benefit side is how to create some of these systems, how to develop effective legal services at scale, just in time, just enough services that address people's jobs to be done. And that's going to require, more interdisciplinary work. I don't think, every student should take coding for lawyers. And I don't think so. I think what they should do is partner with people who know how to code and educate engineers on how law offices work, how what the ethical obligations are of lawyers, and then we as lawyers get to understand a little bit of what the technology can do. And I think that those sorts of interdisciplinary partnerships are really essential for Lawyer 3.0.
All right. Well, Ray Brescia, author of Lawyer 3.0 and professor with the outstanding title at Albany Law School. Thank you very much for coming on. This has been a great conversation.
Yeah, thank you, Ray.
It's been a pleasure. Thank you.
And thanks to all of you, our listeners, for taking the time to listen to the Geek and Review podcast. If you enjoy the show, share it with a colleague. We'd love to hear from you on LinkedIn.
And Ray, where should listeners go to pick up your book, Lawyer 3.0?
Most online bookstores, Amazon, Barnes and Noble, bookshop.org, wherever you can get your books. It's not, as an academic press, it's not in a lot of bookstores physically, but you can easily find it online.
Awesome.
Great. And as always, the music you hear is from Jerry David DeSica. Thank you, Jerry, and goodbye, everybody.
Bye.